नमस्कार दोस्तों, जिस विषय पे मैं बात कर रहा हूँ वो टॉपिक है कवरेज बाय कंज्यूमर प्रोटेक्शन एक्ट सर्विसेज ऑफ डॉक्टर्स। ये डॉक्टर्स अपने को सर्विस देते हैं हॉस्पिटल में। द सर्विसेज रेंडर्ड बाय द डॉक्टर इज रॉन्ग और नॉट एक्सपेक्टेड एज पर द डॉक्टर्स रेगुलेशन बार सिस्टम और एज अ सर्विस हैज़ टू बी डन बाय द डॉक्टर। अगर कुछ वैसा गलती हुआ या तो डॉक्टर्स जिस पेमेंट के बारे में ऑपरेशन करे या तो सर्विस दिए वो गलत है या कुछ भी ऐसा रहा तो क्या डॉक्टर के अगेंस्ट कंज्यूमर फोरम में अपन केस डाल सकते हैं? नहीं। ये 1995 में एक जजमेंट आया था। ये जजमेंट क्या, डॉक्टर्स कवरेज बाय कंज्यूमर प्रोटेक्शन एक्ट। द एप्लीकेबिलिटी ऑफ द कंज्यूमर प्रोटेक्शन एक्ट टू डॉक्टर्स रेंडरिंग मेडिकल सर्विस टू द पब्लिक has been a subject of wide discussion among the professionals. In view of several doubts expressed as to how and in which manner the Consumer Protection Act shall be implemented, the court rendered clarification as follows. सर्विस जो डॉक्टर्स देते हैं उसके बारे में क्या गाइडलाइंस रहे तो अच्छा है, नहीं तो कैसे द डॉक्टर शुड बी प्रोटेक्टेड और वेदर कंज्यूमर प्रोटेक्शन एक्ट है वो डॉक्टर को लागू होता नहीं होता, इसके बारे में ये जजमेंट में कहा गया है। कुलदीप सिंह वर्स या के इंडियन मेडिकल एसोसिएशन वर्सेस वीपी सांता एंड अदर्स, AR 1996 सुप्रीम कोर्ट 550। ये जजेस कुलदीप सिंह, SC अग्रवाल एंड BL अंसारिया। ये जजमेंट 1996 का है। इसमें क्या कहता है, सर्विस रेंडर्ड टू ए पेशेंट बाय मेडिकल प्रैक्टिशनर एक्सेप्ट वेयर द डॉक्टर रेंडर सर्विस फ्री ऑफ चार्ज टू एवरी पेशेंट और अंडर ए कॉन्ट्रैक्ट ऑफ पर्सनल सर्विस बाय वे ऑफ कंसल्टेशन, डायग्नोसिस एंड ट्रीटमेंट बोथ मेडिसिनल एंड सर्जिकल वुड fall within the ambit of service as defined under section 210 of the act. The fact that medical practitioners belong to the medical profession and are subject to the disciplinary control of the Medical Council of India and or the state medical council constituted under the provision of the Indian Medical Council Act, which not exclude the services rendered by them from the ambit of the act. A contract of personal service has to be distinguished from a contract for personal service. In the absence of the relation of master and servant between the patient and medical practitioner, the service rendered by a medical practitioner to the patient cannot be regarded as service rendered under a contract of personal service. Such service is rendered under a contract for personal services and is not covered by exemplary clause of the definition service contained in section 210 of the Act. The expression contract of personal service cannot be confined to contracts for employment of domestic servants only, and the said expression would include the employment of a medical officer for the purpose of rendering medical service to the employer. The service rendered by a medical officer to his employer under the contract of employment would be outside the purview of service as defined in section 2 clause 1 subclause 0. Service rendered free of charge by a medical practitioner attached to a hospital, nursing home or medical office employed in a hospital, nursing home where such services are rendered free of charge to everybody would not be service as defined under in section 210. The payment of a token amount for registration purpose only at the hospital, nursing home would not alter the position. Service rendered at a non-government hospital, nursing home where no charge whatsoever is made from any person availing of service, and all patients, rich or poor, are given free service is outside the purview of the expression service. The payment of a token amount for registration purpose only at the hospital, nursing home would not alter the position. Service rendered at a non-government hospital, nursing home where charges are required to be paid by the person availing of such services falls within the purview of the expression service. तो ये कुछ पॉइंट्स है। तो इसमें लास्ट में क्या कहते हैं, एक्सपीरियंस सीम्स टू इंडिकेट दैट कवरेज ऑफ डॉक्टर्स बाय द कंज्यूमर प्रोटेक्शन एक्ट इज़ नॉट प्रॉपर. It is eroding the confidence and trust which should pervade the relation between the patient and doctor. Moreover, the insurance cover obtained by the doctor is open to abuse with or without the intervention of the consumer court. A separate law may be enacted on this subject with adequate safeguard for the patient doctor case of any breach of professional ethic on the part of the latter. Once a doctor is threatened with action against him in a summary course, he loses all his composure. So doctors के service को whether it could be brought under uh, this particular act covering Consumer Protection Act is a question which is always been in before the scrutiny of judiciary and Consumer Protection Act and the Medical Council of India. So these things are to be regularly pursued, and the courts have to give day-to-day observation on this, and authorities has to be made. Even the Medical Council of India and the Consumer Protection Act, everything has to be taken into account. So such is the case with regard to Consumer Protection Act, whether doctors rendering service comes under that particular act or not, and the rules which will be changed day to day. If one day or the other the Consumer Protection Act whether prevails or not is a question that will be decided by the judiciary or the Consumer Protection Act. Even the Medical Council of India has to look into this matter. But as per this judgment, the court says it could not be brought under the purview of Consumer Protection Act.